No?
Hi.
How are you?
Good.
Good.
What's the camera for?
For me?
To show,
The camera is allowed during the open meeting. I'm not aware of anything that allows it during a hearing.
And I'm not aware of anything that restricts it. Can you show me where a restriction is?
Well, I don't want to be filmed, so that would be a restriction.
Okay, so it won't have to be filmed, it'll be recorded.
I don't want to be recorded either.
Well, I have a legal due process right to this hearing.
You do, but it's not to be recorded.
I'm
not
going
aware of anything
to
that allows
record
you
it.
to
I'm going to record this. If you deny me my due process, then you're not going to prevail.
I see. Okay. So we'll start with the first hearing. Mr. Grossman, right?
Dr. Grossman.
Dr. Grossman, thank you for coming this evening. You have received the information from the management company on the open violations.
On the alleged open violations, yes.
The floor is yours.
Okay. There are two violations I received, one regarding an air conditioner and one regarding a basketball hoop. The basketball hoop, there's basically three arguments. The first argument is I'm in compliance. The rule that's in the ARB, it says that movable basketball hoops are not permitted in front yards except when on or adjacent to the personal drive and shall not impede the use of the common drive. That's the rule. And when I proposed that to Armstrong, and that my hoop is adjacent to my driveway, he then goes on, he doesn't deny that, and he says the portable basketball net is currently in your front yard facing the common drive, correct? As a result, the common drive is the court for the net, okay? The new guidelines state that the net needs to be on or adjacent to the personal drive such that the court is your personal drive. They do not state that. And since he's trying to enforce a covenant on the basis of a rule that doesn't exist, you can't enforce it. That's argument one. Argument two is that based on precedent, you won't be able to enforce because of an estoppel. From 1997 to about 2 years ago, there was a basketball court on the Bonicelli's property, pole with cement and ground. The net overhung the pipe stem and faced the driveway of the Brenzis. About 2 years ago, there was an accident where the sows, and that basketball hoop was played with by the Bonicelli family, my family, the Torellis, and the Brenzis. About 2 years ago, there was an accident that knocked that down partially, and Kathy Bonicelli paid Chris Brenzi to remove it.
can I ask a quick question?
Sure.
I'm just trying to make notes. So there was an accident.
Yes, it
Let me
was.
finish. An accident with the basketball court.
Yes.
That was on the common ground.
That was on the common ground.
That's all I need. Go on.
Yeah, it was one of the Sow children backed into it and bent it.
Because it was on the common ground.
No, the pole was in. The
No, you
pole
said-
was in.
A second ago you said it was facing the common ground. I'm just
We
trying
can
to-
review what I said. I just want to tell you what
Sure.
the situation is. The
Sure.
pole, I didn't get out there as a surveyor. It was in a cement block that was in the dirt that was off to the side of the
Facing the common ground.
facing the common ground.
And there was an accident.
The accident occurred.
I got it.
Really not.
I got it. I'm sorry. I just started trying to-
technical. It's not common ground, it's the common drive.
The common drive.
You're right. You're right.
The common ground is property owned by the association.
I'm sorry.
We're going to stick to the...
Got it. I apologize. Go on.
Okay, is that clear now what the situation is?
Perfectly clear.
Okay. And so that was removed. And the fact that that had been there, 97, for at least 10 years, during which time there were multiple inspections of properties. I know this factually because I had another complaint, which I resolved. There was never a request to take it down. I had spoken to Kathy numerous times.
Excuse me.
Yes,
How does this apply to the violation in question?
because there's a precedent of a
What's the
basketball.
precedent?
That in order to prevail in court,
That's not the question. The question is, what's the precedent?
the precedent is that the basketball court was there for 10 years.
So in your example, somebody commits a crime for 10 years, never caught, then they're caught.
It depends the nature.
What does it have to do for the last 10 years?
There is an issue here of selective enforcement. In order for a homeowner
Is
association,
your argument selective enforcement of this specific case?
Yes.
Or in general?
the argument is multiple examples of selective enforcement, possibly driven by animus and possibly driven by religious animus.
Okay, that's all I wanted to know. Because I don't really think the details are for me anyway.
Well, I want to lay out the details. So, that basketball court was there, and it was used by everyone. And in fact, as a matter of law, if a minor law is not enforced, that's the whole meaning and the purpose of an estoppel. It can't then be arbitrarily enforced.
This basketball net was where yours is now?
Opposite the pipe stem, as if we
The
were
other side.
on the other side. I could draw you a picture if you want to.
No, you give no word pictures.
Okay. Now, argument 3, which kind of ties to argument 2.
What's argument 2?
Argument 1 is that I'm in compliance because the fellow from Armstrong raised an issue of noncompliance that doesn't exist in the rules.
Yeah,
That's argument 1. Argument 2 is that there is a precedent that this has been here and that based on that precedent, I assert my right to maintain the basketball court there. Argument 3 is the selective enforcement. The homeowners association is required to enforce its rules in a non-selective uniform manner. I believe that this whole issue arose by a complaint from Pat Brenzy, and I believe it's driven by personal animus and possibly by personal religious animus. That opens up a whole ugly story of civil rights violations and fair housing violations. Yesterday, I went around the neighborhood and photographed about 8 such basketball courts. You cannot claim that in all the inspections of all these years they were not enforced. And the whole issue of a new board coming in and trying to enforce covenants is a really that have been ignored for a long time, is a very sticky legal issue. Now, in this picture of about 8, I could look them up, there are 2 cases where the basketball courts on pipe stems are situated in a full court position. There's one pipe stem, another basketball court. And therefore, I claim, unless you want to show me contrary, that you're in a process of having those removed, that this whole matter is a matter of selective enforcement against me, driven by animus. I do want to say that, and possibly religious animus, I want to say if this goes further, and I hope it doesn't, we will get to the bottom of this animus. And it could be very ugly. So that's what I want to say on the basketball court.
So, you bring up religious animus.
Yes,
You use the term possible.
yes.
That means that there is not a likelihood that that's the case.
It doesn't mean that. You will not, I do not know, as a matter of fact, who the complainant is. or if this was in fact a routine inspection or a response to a complaint. In discovery, I can get that information. If I get that information, we can then dig further.
What about the second violation, the air conditioner?
The air conditioner. The second violation is the air conditioner. About 2 years ago, year and a half, I started making some improvements. I call them improvements, you might disagree, to help the life of my autistic son. And one of that was to situate a new basketball court. Another one is to build a shop in the garage. He likes to work with tools. And part of that was to make the shop usable, was to put an air conditioner in the shop. As an aside, I want to say it's, to me, a badge of poverty on the Homeowners Association that all four of you are here taking this up, but not one of you ever came over, and you know I have an autistic son. Not one of you ever came over to ask, how is he doing? Is there any way we can help? But we're here to enforce. And let me just say something. When we face our Maker, he's going to not ask you, how well did you enforce the covenants? He might ask you, were you ever kind to the little boy I sent down there? The one who has all that difficulty, who may never have a friend and may never have a job?
Excuse me. Could you please stick to the point? Because I don't think it's fair that you're transferring that to us. We all do our own things.
That's exactly my point.
It is exactly my point. I spend a lot of time as a volunteer with children, and I don't appreciate your comments.
Great.
So keep it to the point.
And I don't appreciate being here, but I'm here.
That's not the point. You have a contract with the association, and the association has said that you are in violation of those things. You are not here to judge us. When I get to my Maker, I'll be glad to put all the good and bad in front of him, but it's not for you to decide.
I am not,
Please
believe me, I am not deciding.
Please stick to the point.
Please go ahead.
Believe me, I am not deciding, nor am I capable of deciding. All I know is I have the custody of a severely impaired boy that I have to deal with, and to make sure his life is as meaningful as possible. So anyway, getting back to the point, I put this there. I checked the guidelines that were enforced at the time. I thought I scrubbed them and did not see any restriction on air conditioners in the front. When this issue first came up, and I received the first letter of complaint about a year after, so a year had passed before I received the complaint, I wrote to the association, to Armstrong, in the name of the association, that I looked over, I didn't see any violation, I am not perfect. If I have been in violation because of some clause I missed or something on air conditioners, and that we don't have a searchable PDF file, so I am somewhat at the mercy of my review abilities, please point it out to me. And then I take the air conditioner down the next day. I am not looking to make trouble. What I would have then, and I bought this air conditioner, $150, for this purpose, and I researched it. I could have bought an air conditioner that doesn't stick out the window. I could have bought one that sits on the floor. I could have bought one that, a through-the-wall one. This was the cheapest way I had that looked to me in compliance. So then, I don't know when this all started, July or whenever, I get the notice that I'm not in compliance. And I said to him, look, exactly what I just told you. Look, if I missed it, please point out to me the previous, and I'll take it down the next day. The fellow from Armstrong did not. He wrote to me that the paragraph that applied last year was the neat appearance. Now that's very problematic from a legal viewpoint, because if that's the case, in the multitude of inspections, how come I hadn't been given a citation in the previous year? So it looks like a matter of him fishing to try to justify the fact that I should have seen that it was